This is Suzanne Bouchard, instructor with American Institute for Paralegal Studies. One of the basic concepts we learn about in real estate law is the concept of ownership. This lecture will cover the different types of concurrent ownership of real property. Some of the ideas for this lecture are derived from Chapter 2 of our textbook, Practical Real Estate Law, the 5th edition by Daniel F. Hinkle. Real property may be owned by either a single owner or it may be owned by more than one owner. When you have a single owner acquiring real property, this is known as ownership in severalty. If more than one owner acquires real estate, this is called concurrent ownership. There are 4 types of concurrent ownership of real property. There's joint tenancy with the right of survivorship, tenancy in common, tenancy by the entirety, and community property. Not all types of concurrent ownership exist in all states, and where the property is located, the laws of that state govern how the concurrent ownership can be held. So if you have a piece of property in Montana and it's jointly owned, then the laws of Montana apply for the concurrent ownership. So now let's discuss these 4 types of concurrent ownership in a little more detail. Joint tenancy with the right of survivorship is recognized in most American jurisdictions. And as our text points out, joint tenants with the right of survivorship own equal shares in the real property, and on the death of any owner, the deceased owner's interest in the real property passes to the surviving owner. So for example, let's say Joe and Bob own a piece of real estate as joint tenants with the right of survivorship. They each have an equal interest in the property, meaning they each have the right to use and possess the entire real property. When one of them dies, the deceased owner's interest passes by operation of law to the other owner. Joint tenancy with the right of survivorship can be created by either a will or a deed, and it usually occurs when real property is transferred to 2 or more persons with express language specifying that they take the property as joint tenants with the right of survivorship. Without that specific language in the conveying instrument, the parties usually take it as tenancy in common. A tenancy in common is a form of concurrent ownership in which 2 or more people are entitled to possess the same property. Now, one big difference between a tenancy in common and a joint tenancy with a right of survivorship is that with the tenancy in common, there is no right of survivorship. Each owner's interest in the real estate passes by will or inheritance when the common owner dies. So let's say Joe and Bob own a piece of real property as tenants in common. If Joe dies, his interest in the property will not pass by operation of law to Bob. Instead, Joe's interest will pass by will or inheritance to Joe's heirs. Another big difference between a tenancy in common and a joint tenancy with the right of survivorship is that the owners may hold unequal shares in the real property. For example, Joe may own 1/4 interest in the property, while Bob owns the remaining 3/4. The 3rd type of concurrent ownership in real estate is the tenancy by the entirety. This is a form of concurrent ownership between a husband and a wife. It is available in several states. In a state that recognizes tenancy by the entirety, a conveyance of real property to a husband and wife automatically creates a tenancy by the entirety, unless the will or deed specifies otherwise. The tenancy by the entirety contains a right of survivorship in which one spouse's interest in the real estate passes by operation of law to the other spouse upon death. This is really similar to a joint tenancy with a right of survivorship, but it's just between a husband and wife. If the husband and wife happen to get divorced while they own the property, then the tenancy by the entirety is converted into a tenancy in common. The 4th type of concurrent ownership is community property. A minority of states in the U.S. recognize community property, and it holds that as a general rule, all property acquired by the parties during the marriage, either jointly or individually, is community property. Community property is owned equally by the husband and wife, and it cannot be conveyed without the other spouse's consent. Property that's not part of community property is called separate property, and separate property includes property owned by either spouse before the marriage, or property acquired by either spouse during the marriage if it's acquired by gift, inheritance, bequest, or devise. So there's a brief look at concurrent ownership of real property. As you can see, not all the different types of concurrent ownership are available in all states. So a paralegal working in real estate law should be familiar with the different types of concurrent ownership that exist in his or her state. If you're not currently a student at AIPS, and if you're interested in learning more about careers in the law, please visit our website at aips.com.